Finally, 1 week time is granted for removing the office objections.
My lord, appearing for the appellant in serial number 4, my lord. My lord, a week's time may be granted, my lord.
Oh, sorry. Putting hot shit. Dismissal appeal for non-compliance office objections. See, on 28/2/2020, an order was passed that if the 2 weeks time was granted, making it clear that appeal would be dismissed. So office objections are not cleared within 2 weeks.
Yes, my lord. My lord, we had to receive a reference petition from the trial court in Mysore, my lord. The record shows that
This was the order. This was the order. I go by this order.
Please. Apologies.
Purple. Appellant's counsel prays for time to attend to the office objections. First up, on 28/2/2020, order was passed to the effect that office objections would not be cleared within 2 weeks from that day. The appeal to be listed for dismissal. Full stop. Since then, office objections have not been removed. Full stop. Prayer for adjournment cannot be entertained before appeal is dismissed. Third time. 2 weeks finally. Yes. Non-compliance second time. Absent 2 weeks.
Suresh Kumar, yes.
Same.
8. Manjuna.
Absent 2 weeks.
9. Shobhi Shetty.
$50.
Proceedings were conducted by the constituted authority minister. There is no date. Then accordingly, put this one under the proposal. As per Article 3, subclause 3.
What is that? What is that?
Schedule 2. Appeal from a decision or an award or order inclusive of an order determination under etc. and not otherwise provided for when presented subclause 3 matter to the High Court where the order was passed by a subordinate court or other authority comes to table. If the order relates to suit or proceeding, the value of which exceeds 1,000 rupees, in any other case, 8 rupees. Accordingly, as would be of 50. That is my submission. The court is not fixed. It is appeal to the High Court. Any order passed by any authority or subordinate. appeal to High Court. Any person accused by an order of central government under section 18 of this act
When
may,
order was
within
changed, the property is
period of 6 days from the date of communication or receipt of the order, file an appeal to the High Court on any question of fact or law arising from such order. And upon such appeal, the High Court may, after hearing the party for such order, thereon anything from. So that if the High Court may is satisfied that appellant was prevented, there is no limitation. Right within limitation.
Who has passed the order now?
Actually, Ministry of Home Affairs, Government Letter. Subject is in this matter.
The counsel for the appellant submits that this appeal is preferred under section 18C of the Enemy Property Act. And issue Article 3. Capitally Roman small 3. Possibly small e, bracketally. Article 3, bracketally Roman small 3. Matte bracketally 1. Matte bracketally clause A, small a. Schedule 2 of Karnataka Court Fees and Suits Valuation Act 1958 is applicable. Therefore, rupees 15 is paid. So in this view, appellant need not state the valuation. Subjection is overruled. For admission, only one objection. List for admission. Yes. Where are they? Yes. List for admission. Both the cases. 9 and 10. 11 is same. 11. On complaints officer first time. How much time you want? 1 week. 11 or 1 week. Yes.
All matters are connected together. First matter is the limit of that. Second, that why is of that limit of.
I don't know. Automation is barely. Yes.
Connect as matter to common.
All these 3 appeals number activity. We posted on the same date together. Let's see, first you remove the office objections in item number 11. Yes.
By oversight, I have mentioned that Article 4 that will be submitted to
In Article 4, valuation statement.
Valuation people correct ಮಾಡಿದ್ದೇನೆ. It is there in the mail of para number 29 ಅಲ್ಲಿ by oversight.
I ಮಾಡಿ. Yes, ಮಾಡಿ. Yes, ಮಾಡಿ. Yes, next.
My lord, in this case, I appear for the appellant, my lord. The objection is that, my lord, the valuation, my lord, would be less than rupees 10 lakhs and therefore the appeal will lie before the district court. My submission is that, my lord, the enhanced amount is rupees 8,000 per gunta. That is to the total extent of 3 acres, 2 guntas. The value of which, my lord, would be 9,76,000. If the solution, my lord, as awarded therein at 30%, my lord, is taken into consideration, the total value will be 12,68,800. Therefore,
How much enhancement you claim?
claim enhancement, my lord, is calculated. Enhancement, my lord, if calculated, would be 9,76,000. Solution ಸೇರ್ಕೊಂಡು ಯಾಕಂದ್ರೆ solution
ಆಗಲ್ಲ. It follows. Solution and everything follows the compensation. It cannot be subject matter.
Well, my lord, your lordship may permit me to present it before the appropriate, and I have paid, my lord, 59,000 so also towards court fee, my lord, deposited. That may also be.
The office has raised objection with regard to maintainability of the appeal in view of the pecuniary jurisdiction of this court. According to the registry, this appeal should be preferred before the district court in view of valuation of the in view of valuation being less than 10 lakhs. Now the counsel for the appellant seeks permission to withdraw the appeal and present the same before the district court. So hence permission is accorded. Appeal memo shall be returned to the appellant's counsel for being presented before the concerned district court. Most of the court fee payable paid here on the appeal memo shall be transferred to the district court.
Much of that.
Stop. If the appeal is presented before the concerned district court within 30 days from today, question of limitation will not arise. Yes.
Much of that.
13, Hari Chenna.
Awaiting a service of notice with respect of respondents. List after completion of service on the respondents. Yes.
Nayak.
Acceptance of note caused by claim. The appellant's counsel is absent, but full stop. But a note is made. The cost title of the appeal memo that objection. Respond number 10. That is number 10 is not a made up, is not in with the sentence.
But a note is made. Respond number 10. That is different.
Not made a party to this appeal. It was deleted. So this note is accepted. This first time appellant's counsel absent. 3 weeks time is granted for. I go for retirement. Yes. 1 to 4. Appellant's counsel is present. Notice ಕೊಟ್ಟಿದ್ದಾರೆ. Counsel for R1 to R4 has filed a memo seeking permission to retire from the case. But notice of retirement is not given in this view. Memo cannot be considered. Yes. Yes, next.
Vijay Krishna Bhatt.
Service of notice to 1 more. Sorry, everyone, okay. How many times you have taken notice?
3 times.
Appellate's counsel has filed an application as per IA 1 of 21 seeking substitute service on respondents 2 and 4. Another daily. Prabha. Bangalore edition. Notice issued by this court on earlier occasion 3 times. Respondents 2 to 4. Notices have not. The affidavit it is stated. Respondents 2 and 4 are residing in the same address and that they are intentionally evading to receive the notice. Huh?
Earlier 3 times.
Have not been served. Who are residing in the same address. Evading the service of notice on them. Applications alone. Appellants are permitted to take out notice to respondents 2 and 4. Newspaper Kannada edition. The registry is directed to release draft, indicating the date of publication, date of appearance of respondents 2 and 4.
Vijay Angadi.
By this one. What do you say?
Not having a serious objection. Was not I will not have any objection.
But I will take it. Okay, person. Application under section 151 CTC for releasing the deposited compensation. Where the amount is available, deposit the tribunal. That compensation amount has been deposited. Yes, to what is the amount? Is that amount of rupees 4 lakhs has been deposited by the council or application. So taking into consideration the circumstances narrated in the affidavit, respondent is hereby permitted to withdraw 50% of the deposit amount. So the respondent shall execute an indemnity bond that in case the appellant succeeds in the appeal, we shall repay the entire amount. Okay. I1 of 19 is allowed.
appeal, my lord. It's based on the arbitration suit dismissed, my lord. That, my lord, earlier the open the demat account, my lord, with the stock exchange. It's a broker, my lord. I opened the account and during the year 2008, the market was crashed, my lord. They are not allowed to close that position, my lord. Therefore, I incurred a loss. They have arbitrarily sold the share, my lord, because of market crash without giving the opportunity to me. After that, my lord, they have sent a notice that there is a credit balance against me, and they have initiated arbitration proceedings in Chennai, my lord. I filed an application, reply to the arbitration award. Arbitration proceedings, I filed a reply, my lord, denying the allegation and also claiming a counterclaim that because of they are not allowed me to sell the share on the particular day, I have incurred a loss, my lord. But without considering that arbitration award was passed, that was in annexure page number 35, my lord. I filed a reply through post, my lord, and
Please tell the reason for delay.
delay, my lord.
Don't, I want,
Yes,
don't
my
want
lord.
merit.
Yes, my lord. 2016, the award was passed in OS suit, my lord. That award was dismissed. During the time of award passed, I was working in a Bangalore as in Temple, my lord. Because of that, award was not communicated me. Once this execution proceedings was initiated against me on 2020, I came to know that they have initiated this award was passed. OS A suit was dismissed, allowed, and that execution proceedings was initiated, my lord. Then immediately I approached it and filed this appeal.
When did you come to know about the award?
Sorry?
When did you come to know about this suit being disposed of?
In 2020, I came to know.
Where have you stated?
In paragraph number 5, my lord. Marked only after receipt of the summons in execution proceedings 14/20.
Please read paragraph 5.
I submitted during the month of March 2020 only after receipt of the summons in execution petition 14/2020 filed by the respondent number 1. I came to know that the said arbitration suit was dismissed on 27/10/2016 by the principal district judge at Udupi. Immediately, I approached my advocate. I took legal advice from my advocate at Udupi to give an opinion regarding filing the appeal before Honorable High Court. After obtaining the oral evidence by my advocate, oral advice by my advocate at Udupi, I have decided to take up the matter in the court.
When did you receive in the month of March 2020?
Please, my lord.
You received the
Summons from
notice in the execution. When did you file this appeal?
appeal I filed, my lord.
12/2/2021.
Yes, my lord. 1920.
Where is the explanation? Explanation from March 2022.
That subsequent paragraph I mentioned, my lord. I am unable to forward the court papers to my advocate at Bangalore to file appeal due to COVID-19. After that, I have obtained a certified copy from the Udupi court and papers to the advocate at Bangalore.
Did you appear in the suit?
Sorry, my lord.
Did you appear in the
Yes, my
suit?
lord, I have appeared.
Then how can I believe? How should I believe that you came
My
to
lord,
know?
at that point of time, I was in Udupi. And subsequently, due Temple, I am working in Bangalore, my lord. Therefore, there is a communication gap between advocate and me, my lord.
Yes.
The respondent number 2 replaced it part, and regarding the R3 National Stock Exchange, I am not. They are both are expert and not filed a memo. That's the last.
Notice to all to. Notice to all to Devendra Kumar and confirmation for R1. Advocate, sir.
2-3 dispensers, my lord.
R3 next. ಹಾಕಿಬೇಕಾಗಿಲ್ಲ.
R2 and R3 placed expert in AS also. Arbitration. I think I'm mixing. Yes, sir, they appeared last hearing.
Arbitration Act ಕೊಡಿ. There is a delay of 1,001 days. Section 37 of the Arbitration Act. So therefore, application section 5 of the Invitation Act is filed. So, what's your name? Indiraj, Learned Counsel for the appellant. Stop. Respondable 2 has been served, but represented by counsel, but counsel is absent. The counsel for R1 is also absent. So number 3 has not appeared in spite of service of notice. It is stated that the appellant came to know about the disposal of the arbitration suit 2 of 2009 when he received Notice in the execution case in the month of March 2020. So the suit was disposed of on 27/10/16. So consulted his counsel and he was advised to prepare an appeal. So thereafter he could not come over to Bangalore. Because of pandemic COVID-19. Then he filed this appeal on 12/2/2021. Yes. According to the government did not allow him to sell shares. Rather, who sold the shares?
Number one himself sold.
Monetary interest of the appellant. Monetary interest. The appellant is involved. Period view may be taken. So the appellant has to be subjected to cost. Therefore, application is a note. Is 5,000 payable to the government. Some delay is condoned. If the appellant pays the cost and produces receipt, that may be listed for admission. Yes.
And he failed to execute the sale, therefore he filed a suit. Suit was at the time of summons was duly served. And he has not appeared by set. Again, he comes with an application to set aside the expert, that was allowed by the and by the wakalat and entered appearance, but he did not stoop to file any evidence. And even the honorable court has granted TI.
ಯಾತಕ್ಕೆ ಬಂದಿದೆ ಇದು IA 1/22 for posting the appeal file for it?
Or the condition to deposit money. You are not even complying the order.
ಏನು condition order?
In matter comparison, court has passed an order to deposit the 10 lakhs. Even today also they have not deposited the set amount also.
Where is it? On what? Where is the order? $10 lakhs towards what? 10 lakhs towards what?
They are not paying deposited.
ಯಾವುದಕ್ಕೆ ಸಂಬಂಧ?
It is a suit for specific purpose. We have paid 30 lakhs. In 2015, this court passed an order to deposit the 10 lakhs amount. Even that also they are not depositing the trial court. Or in this
Execution decree. Subject to the appellant's depositing 10 lakhs before the executing within 2 weeks. You are the purchaser, huh?
I am purchasing. Try to sell agreement. and paid 30 lakhs in year 2015 itself. My lord.
Although why the appellant was directed to deposit 10 lakhs? What was the reason?
At the time, ex parte order, only I came to know after filing the wakalat. As a condition of passport is put to deposit 10 lakh amount. We get interim order. That was also they have not deposited.
It's not deposited now.
Not till today they have not deposited. Last time they have taken time. Last time this taken for hearing. Any apparent mistake petition that was also dismissed, my lords. He admits service of summons. He also admits filing wakalat, everything.
Appellant's counsel is absent. Counsel is present. It's that IA 122 is filed by him. IA 2 of 21 is filed by IA 1 of 22 is filed.
One of 22 is for posting.
IA 1 of 22 posting.
Of 21 for vacating.
IA 2 of 21 is filed by him for vacating the out of stay. Passed on. Eight 10/21. He submits that as ordered on you appellant submits that on 8/10/2021. This court, while granting stay of execution, the decree in OS 1803 of 16 directed the appellant deposit rupees 10 lakhs before the executing court. And so far, this amount has not been deposited. Okay. Full stop. The affidavit also stated by the appellant that this 10 lakhs has not been deposited by the appellant. This allegation in the affidavit, this averment in the affidavit is not refuted by the appellant. Therefore, since the appellant has not complied with the action of this court, an interim order cannot be allowed to remain. Therefore, IA 2 of 21 is allowed.
Lord, in 21, I appear for the appellant, my lord. In 21, I appear for the appellant. Ex parte judgment and decree of the trial court was challenged by way of a miscellaneous petition, my lord. Lord, medical certificate was given. The learned trial judge, my lord, has dismissed it on the ground that I did not examine the doctor. You have given medical certificate. Please look at ink page 27 of the order, my lord. Ink page 27, para 16.
P2 is a medical
Exhibit P2 is the certificate of the so and so suffering from enteric fever. Document reveals that as if the petitioner is advised so. Doctor who issued medical certificate has not been examined. Then similarly at page 30, paragraph 21, the petitioner himself is examined as PW1, reiterated petition averments. Though he has stated in his cross-examination that he will examine the doctor who issued the medical certificate, he has not examined the concerned doctor. He has also stated he has taken treatment at Victoria Hospital. Then therefore, my lord, at page 31, last line of the page, exhibit P2 medical certificate is not proved as required under law. Now, this is in the teeth of order 26, rule 1. Explanation, my lord. This is the only ground on which he rejects the petition.
Have they disputed your illness?
No. This is the only ground. He is the resident medical officer of Victoria Hospital. And if your lordship sees the medical certificate, it is not a one-page document. It is a detailed 2-page document. He says, I have asked him to undergo tests. After examination of the tests, I find that he's suffering from so and so. So there's a very detailed medical report. It's not a certificate, it's a medical report that is given. Our resident medical officer na Victoria Aspatreinda illi ಕರೆಸ್ಬಿಟ್ಟು ನಾವು ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ that is not what is contemplated. Explanation, my lord. The lordship may kindly see order 26, rule 1, my lord. Cases in which court may issue commission to examine witness.
Yes.
Does my lord have
Yes.
rule 1?
Yes.
Explanation. The court, for the purposes of this rule, may accept a certificate purporting to be signed by a registered medical practitioner as evidence of the sickness or infirmity without calling the medical practitioner as a witness. This was inserted, my lord, by the Amendment Act of 1976. And he says in the order of the trial court, you said you will examine the medical officer, you did not examine, therefore I don't rely upon exhibit P2.
Heard opponent's counsel, appeal is admitted. Yes. Response counsel is admitted.
Need to continue. Interim order to continue, my lord.
What date was granted?
It was granted at the time of admission itself, my lord, in 2014. 25/9/2014, I think it was granted.
Still further orders.
Deposit of 10,000 rupees, which I have also deposited.
Still further orders sometime. Not necessary to extend.
Okay. I'm grateful, my lord.
Friends, not Mr. Procedural. withdraw the appeal with liberty to urge these grounds on fresh cause of action. Again, why?
Between 2000 factions of an association. The idea was this championship was being held in 2017. Once I granted an interim order, championship is now over. This petition becoming infectious. In case in future,
Okay, why do you want liberty? Liberty to urge these grounds on fresh cause of action at time.
there is a dispute between two factions.
Ah.
Of a Taekwondo association. Each faction member was claiming right over the persons to send it by association of second federation. There was a faction that tried as well. What was the first declared for this court? And this court granted permission for both the factions to send the parties to the federation.
To appeal, I will dismiss as infectious, but liberty cannot be granted. Counsel for the appellant has filed a memo seeking permission to withdraw the appeal as it has become infectious. It has also sought, but he has also sought liberty to urge these grounds if fresh cause of action arises. Liberty thus sought by the appellant cannot be granted. However, the appeal is memo is placed on record. Appeal is dismissed as it has become infectious. Liberty ಕೊಟ್ಮೇಲೆ ನನಗೆ ಇಲ್ಲ ಮಾಡಬೇಕಲ್ಲ. It will be misinterpreted. Or strike it out. Appellant's counsel has filed a memo dismissing the suit, dismissing the appeal as it has become infectious. So memo is placed on record. Appeal is accordingly dismissed. Yes.
My lord, this appeal also has become infructuous, my lord. The suit itself is disposed of. I have filed a memo also to that effect.
Counsel for the appellant submits that in view of disposal of the suit on merits, this appeal has become infectious. Full stop. Memo idea nodi. To this effect, memo has been filed. When you filed the memo?
9th February 2022, I had filed, my lord.
Not here. Anyway, submission of the appellant's counsel is placed on record. Appeal is dismissed as infectious, as having become infectious. Just next. Filing the second copy of the appeal memo.
And involved is survey number 52/1 of Parapanakaraha village. Defendant claims SIT survey number 60/2.
You are the plaintiff, huh?
I am the plaintiff. Survey number is survey number 52/1. Defendant's site is located in 60/2. The trial court found that my title is defective. Produced similar contentions were raised in various other suits. Suits came to be decreed in my favor. Regular first appeals were logged before this honorable court. All of them were dismissed. I produced a copy with the documents. RFA numbers 11, 19 and other additional documents are filed at page 48.
Judgments in RFA.
Yes, my title has been upheld. Thereafter, some of them have had moved the apex score. One of the matters was listed day before yesterday. The appeal has been dismissed. My title to survey number.
Did you produce this judgment before the trial court?
No, because the judgment recent afterwards. Trial court, even otherwise, without the judgment, I had produced judgment of the trial court. appeal and produced by the state. But that order has been upheld by the apex court.
Temporary injunction is refused.
Refused by different survey numbers. Mine is survey number 52/1, there is survey number 60/2. They claim I cite. I produced the documents of title of the defendant also, which was produced by the page number 26 scheduled to their title deed. I produced page 26. Schedule. 28.
But the observation is in para 16, please come to page, ink page 16, para
I
16.
cannot prove my title.
No. Boundaries. Plaintiff himself.
All those contentions that were raised in the appeal and
Why?
in the trial court in the other source, that has been confirmed by this honorable court. And bearing survey number 52/1 belongs to me. Their site is located in survey number 60/2. I furnished copies to the other side. Last matter to page 28, I have produced documents. Their document filed before the trial court. Their site is in survey number 60/2. I am the owner of the entire survey number 52/1. And I will upheld by the trial court, confirmed by the honorable court and the apex court.
Mohan Rangam. Mohan Rangam. Let him come. Suppose of
ನಾಳೆ ಹಾಕು, ನಾಳೆ ನಾಡ್ದು.
Nale.
Monday.
Next counsel is present. In what is the stage in the suit now?
Trial ಆಗಿಲ್ಲ.
Respondents counsel is absent. Next week.
Serial number 26, I appear for the appellant, my lord.
Yes.
Senior mathematician.
Huh?
Kindly, explain.
Your lordship may kindly see the order sheet. 12 times he has taken time. If your lordship thinks it is
Interim order ಕೂಡ ಇದೆ ಅಂದ್ರೆ
whatever it is, your lordship may kindly see the order sheet commencing from 21/12/2021. Every date of hearing adjournment has been sought, except once. 13/12/2021, I have taken time. Otherwise, 12 times I have taken time.
What is the university of qualified
Matter ಏನಿದೆ?
ಇಲ್ಲ ಸುಮ್ಮನೆ ಸೀನಿಯರ್ ಆಚಿಂದ ಸ್ಟೇಷನ್ ಮಂಡೇ ಮೇಲೆ
Justification ಇಲ್ಲ ಸ್ವಾಮಿ.
Has already taken that response.
My lord, what has happened in this case? Trust properties are being mismanaged, my lord. The law is we had sought for leave under section 92. The Supreme Court as well as our High Court has held objections cannot even be looked into. If the averments in the petition makes out a ground under section 92, it should be leave should be granted. The trial court proceeds based on
Leave is rejected. Is it?
Huh?
Is
section 92 leave is not granted. The law is even notice need not necessarily be given. I have produced the decision before your lordship. Only averments in the plaint is to be seen. The court I have
ಮಂಡೇನೆ ಮಂಡೇ
ಸಾಕಷ್ಟು ಕೊಟ್ಟು ಎಲ್ಲಾರು ಮಂಡೇ ಕೇಳ್ತೀರಾ, ಕೇಸ್ ಪೋಸ್ಟ್ ಆದಾಗ ಬರೋದಿಲ್ಲ. ಮಂಡೇ ಅಂತ
Monday I will not be in station, my lord. Your lordship
take a date convenient to all of both of you.
23rd your lordship may have it. That is Wednesday.
Is present and ready to argue on admission, but the respondents counsel Vishwanath Shetty is absent. His junior prays for time. Therefore, list on 23/3. So till then, undertaking given by the respondents counsel. Yes.
Your lordship may say as a last chance, my lord.
On the next date, if the respondents counsel does not appear, that will be heard. But it's withdrawn by hearing the appellant's counsel. Yes.
Much obliged, my lord.
Your first state. No.
What has happened is the injunction is granted.
Serial number 27, my lord.
Yes,
I am for the
27.
appellant, my lord.
Yes.
My lord, for the impugned order, I have filed an interrogatory application for staying the operation and execution of the interim order, my lord. My lord, in the IA before the trial court, my lord, they have sought 2 reliefs, my lord, in one IA.
What is the order challenge now?
And I agree. The common order first on IA number 1 and IA number 3, my lord, which is on page number 26, my lord.
Yeah.
In page number 26.
What is the suit for? Suit in.
Suit is for
What has happened is the property belongs to a temple granted by the government and with a non-alienation clause. Then we have a pujari there who was for doing puja and also a Brahmin priest who come and do the puja. In the building, in the property, my lord, adjacent to the temple, we have a small place for living of the pujari. He died. The second defendant is the wife of the pujari. Then, my lord, first defendant was president of the committee. What he does is clandestinely transfers this property into a second defendant in 2018 by way of a gift deed. No, on the strength of that, we did not know this. Thereafter, as a separate committee came in, a different committee. Then, my lord, she started demolishing the building. And immediately the suit is filed. When the suit was filed, it was at the.
You are the defendant.
The plaintiff.
no plaintiff.
Plaintiff.
The
Then,
appeal
my
is
lord,
by the
the
defendant,
building-
my lord. I have to argue.
His wife.
No, plaintiff is the committee, the temple itself, the deity. The property belongs to the deity, granted by the government in 1974 with a non-alienation clause. Then, my lord, at the time of filing the suit, it was just demolished. There was an injunction in force. Then she puts up construction. That the learned judge has observed from paragraph 18 onward. Your lordships may kindly see that. Photographs are produced before the court. Paragraph 18, page 10 onward. The impugned order. Paragraph 18 onwards. Your lordships will kindly see it. Construction had not even.
Gift deed dated so also. First defendant. Temple property was gifted.
Yes, my lord. Without he creates a document of some resolution or something and gives it to the second defendant without any authority.
Now injunction is granted.
Yes, my lord, not to put up construction. Despite an injunction, she proceeded with the construction. That's the observation made by the learned judge in paragraph 20 also. Paragraph 18 and 20. The lordships will find that. She took the risk of continuing with the injunction, the construction, even though there was an interim order. The trial court granted an interim order in our favor. After the interim order, she continued with the construction. That is observed by in both paragraph 18, your lordships will see. Then, my lord, paragraph 20.
What is your rights list? Appellant.
My lord, I drive the lordship attended into the written statement, my lord. We have denied their position and also claim made by them. However, I am in the
Temple property. Temple property.
Exclusively, it is not a temple property, my lord. I have taken a specific contention. Before that, my lord, a very interim application shall not be, because he has to confine for one relief, my lord. The Annexure B, the interim application reads as under, my lord. For the reasons stated in the accompanying affidavit, the plaintiff most respectfully pray the Honorable Court to restrain the defendant number 2 and all persons claiming under her by an order of ad interim temporary injunction from alienating or changing the nature of the suit schedule property till the disposal of the 2 reliefs have been sought, my lord.
The two reliefs are granted now.
Yes, my lord. I read the impugned order also, my lord. What has been prayed in similar manner, the order has been passed, my lord. The operative portion, my lord, ink page number 37. I number 1 filed by the plaintiff and order 39 allowed. The defendant number 2 or anybody claiming under her or hereby temporarily restrained from changing the nature or alienating the suit of property until the disposal of the suit.
That is the only objection.
That is not the only objection, my lord. Technically, because rule specifies that separate applications need to be filed. If it is prayed so, the court, it is the duty of the court as the provided under Rule 23 of the Sealed Rules of Practice to confine, direct the parties to confine to the one relief, whichever they prefer. That apart, my lord, I am residing therein. It is not disputed by them, my lord. I am the priest. Second defendant is the wife of the priest, first defendant. And they are residing there only, my lord. Since the house was in a dilapidated condition, my lord, it was demolished and we were constructing for residential purpose. And due to this interim order, my lord, last year, because of the heavy rain, I was in street, my lord, due to the interim order. Construction was not completed. Even I have made an undertaking in my appeal, my lord. Ultimately, if it is result, whatever my construction shall be in the view of the result of the case, my lord. If they won, I will get it demolished.
What about alienation?
Alienation model, I undertake. We will not alienate it. That condition may be.
What is it, Mr. Jack?
When the injunction order was passed, there was no construction. The interim order was granted. No, you can't say, I will let me proceed with the construction. Yes, you should the matter. You my can you see paragraph 20 of the impugned. Internal page 11. Don't take advantage of doing wrong. She has proceeded despite there being an interim order. Further photographs of the suicidal property produced by the committee, plaintiff committee shows that at the time of filing the suit just begun. Only earthwork was going on. On the other hand, the photographs produced by defendant number 2 show that this construction has come up to roof level as against the condition of the property at the time of filing of the suit. This shows that the defendant number 2 continued with the construction of the property even while the order of temporary injunction was in force. There
was a house where the Pujari was living.
He was living in the house only. What they did was
he died. Pujari died.
He died, and his wife and his son is the Pujari's son is doing puja. What they do is they, without the committee bringing to the notice of the committee about this gifted and all that, they straight away demolished the building. Then immediately we filed the suit for declaration and for injunction. Injunction is granted. What could be done is this, my lord. Your lordship may direct the trial court to dispose of the suit within 3 months. I will cooperate with the trial of the suit. Then if she succeeds, she can proceed with the construction. I know summer is there now. Next 3 months, the matter can be over. Instead of permitting her to why complicate things now.
May I make submission?
Injunction is in force for over 1 year, my
lord. The relationship to the temple, it is admitted. I am the priest. The first defendant is the priest. And my husband is died. We were living there and performing all the puja, everything. When such being the fact, now if it is completed in my appeal memo, para 34, I have clearly stated, my lord, subject to the final result of the suit, I will abide. If I lost, if they won, I will complete the decree, my lord. At least for ground floor complete ಮಾಡಿ ನನಗೆ ವಾಸಕ್ಕೆ ಯೋಗ್ಯ ಆಗಿದೆ.
Where are you living now?
ನಾವು ಅಲ್ಲೇ ಅದಕ್ಕೆ ಶೆಲ್ಟರ್ ಮಾಡ್ಕೊಂಡು ಅಲ್ಲೇ ಇದ್ದಾರೆ my lord.
Yeah, one shelter is there already.
ಅಲ್ಲ where there is no shelter.
Number one is your
separate.
husband. Huh?
No, he is the erstwhile secretary who entered into this transaction. He was the erstwhile committee member, secretary.
Second defendant is the wife of Pujari Purushottam.
Yes.
First defendant yaru?
First defendant was the earlier
Committee member, secretary.
who executed deputed in favor of second defendant. Yes, claiming to be under supposed to be a resolution passed by the committee. Government itself says you cannot alienate at all because that was record seen by the learned judge. Where in 1974, clause 3, it shall not alienate the sites except by of security to a loan for from a cooperative or from government or agency to conduct houses on the land. If there is any violation, the CMC will take over the property, temple will lose the property because of this conduct of defendant 1 and 2. That is why, my lord, I would say, your lordship may direct the try to go on a day-to-day basis. There is no difficulty. We will cooperate as a plaintiff. I will go and give evidence. And
In new suit, why should it go on day to day?
just, I will leave it to your lordship. Now,
What should happen to the old suits?
yes, I would leave it to your lordship. What I am saying is my conduct, because we want to save the temple property. We don't want it to go away. But it belongs
So
to the-
export order was there.
Yes, my lord. Immediately in February 2021, itself expiry order was there.
What was the position when the suit was filed?
The position was that the land was vacant. She demolished, just done demolished and they kept it. The photographs are before your lord. That is why last time I can make available the photographs which are placed on record. The trial court had a look into the photographs and said when the injunction was granted, it was in a vacant, the property was vacant. Thereafter, she has disputed deliberately. Till now, it has come about. She only precipitated. Instead of waiting for an order to be passed, she violated order 39(2)A is not filed somehow. We don't know why it was not filed. There is a flagrant violation of the interim order.
Why did you seek two reliefs in the same application?
Pardon, my lord?
Why did you seek two reliefs in the same application? Appellant is defendant number 2 in OS 9 of 2021. By the principal senior civil judge. The suit was filed by the first respondent. Today, management committee or trust?
Committee, registered committee.
Trust or society?
It is a society registered under the Society.
Management committee registered as society's registration.
Yes.
Registered in society's registration. Suit is in the suit the plaintiff sought a declaration that the dated 1/3/2018 executed by first defendant care of second defendant, avoid, and consequential relief or permanent injunction, restraining defendant number 2 from raising any new construction property that is the plaintiff scheduled to the client. Next para. The case of the plaintiff is that the suit property was transferred by the City Municipal Council, Shumaka. Mr. Sale deed dated 33/1974 with non-alienation clause for a period of huh? All time. Next Adya. The deed itself is void then.
Perpetuity. Any transfer in perpetuity, but we want to avoid that. We should say either accept it or.
The sale deed dated 33/1974 with a non-alienation period clause. Thus, the plaintiff claims to be the owner of the suit property. But the first defendant, care of the second defendant, wife of a pujari of the temple. Stop. Suit property is a residential house. Pujari was living. So the first defendant did not have any kind of right for the suit property for executing the sale deed as a gift deed. Second defendant demolished the house, demolished the existing structure and started raising a or constructing a new further venture was filed and application was also made. That was then the defendant appeared. Then after appearance of the defendant, application was taken up for disposal. Defendants, the second defendant's contention is that she became the absolute owner of the property, suit property by virtue of the gift deed. Husband was a priest of the. Actually, the people belong to their family. Well, the DTT belong to their family, or to the family of her husband. So from times immemorial, the before the family of her husband, her husband have been performing the puja. Husband died on 16/12/95. Therefore, thereafter, the local people of Sadhu Shetty community temple. So actually, the house was constructed by her husband. Since the house was very old, dilapidated, she demolished the house. For the purpose of constructing a new house. So the plaintiff was aware that she was already living in the house. She was living in the house which existed there earlier. So now, therefore, application for sir. For granting the order of temporary injunction in favor of the plaintiff, the trial court has taken into consideration the same deed dated 30/3/1974, executed by the municipality in favor of the plaintiff committee. That plaintiff was the resolution of dated 8/3/2009, according to which number 2 was given the suit schedule to suit property. The trial court has further held that second defendant has not produced the document to show that the The trial court came to conclusion that prima facie it appears that the suit property belongs to the plaintiff. And with regard to the second defendant, it has been observed produced by the plaintiff would show that the time of filing the suit, the construction undertaken by the so then it appears that the second defendant also produced photographs that the construction had come up to roof level. So that has a that when construction for the out of injunction. Therefore, it observed that if construction was allowed to be completed, the interest of the plaintiff would suffer. Stop. The argument of Sri Umesh Mulimani is that the plaintiff claimed two reliefs in the same application. Stop. Injunction filed under Article 39 rules 1 and 2. Stop. Plaintiff claimed injunction to restrain the defendants from alienating suit property and also changing the nature of the suit property. Thus, two reliefs were claimed, which was and the application itself was not in accordance with the practice. The defendant was residing in the house, existence in earlier. She has no house to live. Stated that it's the suit. She will not claim any equity. And that has no intention to sell suit property. So Vijay Kumar, Leonard Counsel for the respondent, submits that the second defendant has no right to construct. Second, when the suit was filed, the ex parte order of injunction proceeded with construction. Consideration the conduct of the order of injunction granted by the appeal vacated. Stop. Next paragraph. Anyway, you're living in a house, don't construct further. If the entire order of the impugned order is perused, find that the trial court has vision in allowing the injunction and granting order of injunction. So it is true that in the application filed by the plaintiff for temporary injunction, reliefs have been claimed. So the court could have examined was the appropriate relief that could be granted in the facts and circumstances. So even now it can be modified. Documents on record shows that the property was non-alienation clause. The defendant number 2 claims his own property deed executed by the first defendant. The right title and interest of the first defendant to execute the gift deed is in question. The sale deed is there showing that the property was usually at of the first defendant by executing the gift deed in favor of second defendant. There was no dispute that when the suit was filed, the property was vacant. But the second defendant had just begun the construction. So the trial that went ahead with construction, violating the interim order.
Sorry for the interruption. May I make a submission? In the plate, my residence and address has been shown the temple beside the temple where I am residing there. They are
how could ಎಲ್ಲಿ ಮನೆನೇ ಬೀಳಿಸಿದ್ರಲ್ಲ ನೀವು can you reside?
ಅಲ್ಲ ಈಗ partially
second defendant
RCC level ಬಂದ್ಬಿಟ್ಟಿದೆ. It is to be completed. That's all.
Though the trial court has granted 2 reliefs in this, under the same application, that order may be the here. But since the sale deed, its alienation by the plaintiff, it is stated that she will not sell. Since the second defendant has stated that she will not sell the property, the interim order of injunction by the very confined second defendant.
My lord, I am an age-old lady, my lord, 67 years.
Therefore, I must examine only the trial court has exercised discretion properly or not. I don't find any infirmity.
My lord, even I can give undertaking that I will not claim any equity, my lord. If the temple plaintiff succeed,
if they concede, I will modify. I don't mind. What do you say, Mr. Vijay Kumar? Better complete and stay.
She is also.
Oh, agala 21 matter.
Construction alla madal matte complication.
In complication.
No, I can't claim any. I am undertaking, my lord. Simply I walk out, my lord.
Very ground floor matter ಕಟ್ಟಿ photograph ಹಾಕ್ಬೋದು. No further. Very ground floor.
My lord, even I go extend, my lord. Ground floor ಒಂದೇನೆ. ಅದರ ಮೇಲೆ
you do one thing. Now the respondent has no objection to complete the ground floor.
Yes, yes,
for the purpose of your living.
Resident.
You should not raise construction the first floor.
Yes, yes, my lord.
You file an affidavit, then I will.
Undertaking good.
Affidavit. Next week, my lord. Party that.
Then this lengthy order is not necessary. Let him file an affidavit.
ನಾನು ಅಷ್ಟೊತ್ತಿಗೆ ಕಮಿಟಿ ಅವ್ರನ್ನ ಕೇಳ್ತೀನಿ.
Next Wednesday, my lord.
Yes, next Wednesday.
Oblige.
File an affidavit that he will not put up any, except the
yes,
ground
my
floor,
lord.
he will not put up.
They will not sublet it or
that he will not alienate. Yes.
Yes.
Find out.
Yes. Consult the committee.
The suit for specific performance filed by the plaintiff Appellant is the plaintiff in this. The respondent number 1 is the partnership, registered partnership. Respondent number 2 is the managing partner. Respondent number 3 is the ordinary partner of the registered partnership, my lord. Respondent number 4 to 7 are the employees of respondent number 3, who is also running a private bar. Respondent number 8 is the brother of the respondent number 3, my lord. My lord, at the time of, my lord, I have filed.
Who executed the agreement?
My lord, the respondent number 1 and 2, the partnership itself has executed agreement of sale in my favor on 18/1/2007 with respect to 5 parcel of land measuring 11 acres 27 cents. Subsequent to execution of the agreement of sale, the respondent number 3 clandestinely has allegedly executed a registered sale deed with respect to respondent number 4 to 8. My lord, I have filed a suit for specific purpose.
Who is respondent number 3?
He's an ordinary partner of respondent number 1, my lord. Now, during the pendency of the suit, I have filed an application again seeking restraining the respondents from alienating the suit schedule properties, and I am enjoying the benefit of the interim order. During the pendency of the suit, the defendant number 4, who is a respondent number 4 in this, has filed an application stating that the plaintiff is allegedly interfering with his possession. IA number 6 is filed by defendant number 4, my lord. His first MFA is arising out of the impugned order passed by the learned trial court judge, allowing the IA number 6 filed by defendant number 4. Now, defendant number 4 has neither filed a written statement nor has he filed any counterclaim with respect to the suit schedule property. Now, there is no claim with respect to suit schedule property from the defendant number 4 till 2019. For the first time in 2019, 22/4/2019, IA number 6 comes to be filed, and there is a specific averment in the IA filed by the defendant number 4. Lord, I have produced the IA number 4 at page 34. Lord, page 38 is the affidavit. The reason for filing the IA number 6 is called out in para 5. May I be permitted to read?
Yes.
My lord, I state that after purchasing 8 schedule properties under the registered sale deed dated 18/10/2008, I am the absolute owner and I am in peaceful possession and enjoyment of the 8 schedule property. The plaintiff was admitting the registered sale deed standing in the name. The plaintiff also sought for a declaration of the sale deed dated so and so, executed by the third defendant in my favor. That itself clearly shows that I am in peaceful possession and enjoyment of the 8 schedule property, without any interference or hindrance from anybody, including the plaintiff. After filing the above suit, the plaintiff obtained an ad interim order against me and the defendants for not alienating the suit schedule property till the disposal of the above suit. I am not going to alienate the 8 schedule property till the disposal of the suit. On the guise of interim order passed by this honorable court, the plaintiff and their agents trying to interfere with my peaceful possession and enjoyment of the 8 schedule property. My lord, under Order 39, Rule 1 and 2, under Order 39, Rule 1A, the defendant can file an application seeking interim order only if there is a threat of damage or wrongful disposition by the
Plaintiff.
My lord, please. This is not the case of the defendant. And the full judge bench of this honorable
He
court.
says that he is in possession and you are likely to dispose.
My lord, that relief can be.
Possession?
My lord, we are in possession of the property.
How do you say that you are in?
My lord, subsequent to execution of the sale agreement, I have taken possession of the property for the purpose of developmental work. I have fenced the property, and defendant number 2 in his written statement has admitted to handing over the possession to the plaintiff. My lord, here the question is.
Which is the document which shows?
Please.
That you were, the possession was delivered to you.
My lord, I will show the document. My lord, I would also like to bring to the notice of this honorable court that the sale deed executed by the ordinary partner without the seal and signature of the managing partner, without due approval of the partnership is void.
That's
There is
different.
no,
That's
my lord,
different.
my lord, it's a
You
void
please show your
document.
possession. Please
I will show,
your
my lord. The second thing is, there is a PCR and a charge sheet filed with respect to the clandestine transaction which is executed, and the case is set for trial with respect to the same transaction. Now, their possession will follow from title. If they don't have a valid title, the sale deed itself is void ab initio. There is no passing of consideration. The consideration was not remitted to the account of the partnership. There was no question of delivering the possession.
All those legal inferences are different.
Please.
You claim to be in possession.
Please, my lord.
Which is a document that shows your possession.
My lord, I will show the written statement of the defendant number 2.
Please show the document.
Please. I filed the memo.
Is it your case that possession was delivered to you on the basis of agreement 53 at TPM?
My lord. Sorry, I did not.
Whether is it your case that the possession was delivered to you?
My possession was delivered to me
under the agreement of sale.
Please, my lord. Subsequent to execution of the agreement of
Where is
sale.
that document?
Please. My lord, in MFA 5939, I have produced the written statement. Paragraph 4 of page 84 is the written statement filed by defendant number 1 and 2, my lord. Page 84, MFA 5939. Page 84, my lord. It is true that in view of substantial advance sale consideration made by the plaintiff hearing, these defendants have handed over the possession of the plain schedule property in favor of the plaintiff. These defendants are aware of the facts. Plaintiff has undertaken minor work of leveling, cleaning the scheduled property, erecting the fence, encircling the scheduled property. If the plaintiff has appointed security guard, same is at his own risk and expenses, and these defendants are not concerned about the same. Defendant number 1 and 2 categorically admit the handing over of the possession subsequent to execution of the sale agreement. My lord, for 4 years, the defendant number 4 did not file any applications on the basis of alleged interference. Only in the year 2019, without any cause of action, without having filed any written statement or WS, files this application under Order 39, which is impermissible. There is a full bench ruling of this honorable court.
First, make it clear on facts.
Please, madam, please. My lord, subsequent to filing of the suit.
Where is the document? I am putting a question. Where is the document to show that your possession was handed over to you? You are laying upon an admission, a statement in the written statement.
Please, my lord. It's an admission. It's an admission in the written statement.
Whether defendant 4 has admitted?
My lord, defendant 4 has not even.
Then?
Defendant number 4 has not even filed a written statement.
Not necessary.
My lord, he has not contested the suit till date. Now the suit is set for trial. The question of possession.
Either he made an application seeking injunction against you. That means he asserts possession.
My lord.
Under the sale deed.
My lord, if he is asserting possession, he has to file a separate suit.
Not necessary.
My lord,
in the same suit, he is a party. He claims to be in possession. You are disturbing his possession.
My lord, under Order 39 rule, Order 39 rule 1 specifically
1A,
1A, my lord.
Defendant claim injunction
Only
against
if there is a threat of damage or wastage, or if there is a wrongful alienation by the plaintiff, which is not the case pleaded by the defendant. Defendant is allegedly filed an application on the ground that there is an alleged interference in his possession. Now his possession is based on an alleged sale deed, and that alleged sale deed is subject matter of the suit itself, my lord. And subsequent to filing of the suit, the defendant number 1 and 2 has filed.
It's a suit for specific purpose.
Please, my lord.
To succeed in the suit, you will be entitled to possession also.
My lord, here the question of possession has been observed by the trial court when there is no specific pleading or averment of the defendant till date. And the trial
Your
court,
case does not fall under section 53A of the Transfer of Property Act. You claim that possession was delivered to you subsequently. There must be a document.
my lord, that I will produce at the time of the trial. My
You are
submission is,
opposing an application for injunction. You must make out your case with documents.
my lord, I may be given time till next week. I will produce the necessary document to show that the document.
Have you produced it before the trial court?
My lord, I have produced it along with the.
You can't produce any new document.
Please, I will not produce. Those were part of the plain documents which were produced before the trial court. I will produce the plain documents. In the MFA, I have not been able to produce the plain documents, but I will produce the plain documents. My lord, in 5939, there is an interim order of stay which may be continued, my lord.
What about these office objections in 28.2?
My lord, in that, the office objection is the suit schedule property mentioned in the appeal and the schedule property which is mentioned in the order are not matching. That is the office objection, my lord. Now
Remove it.
my lord, we cannot, because the mistake is on the part of the trial court while passing the order with respect to.
It needs to be stated correctly in the appeal memo.
My lord, the IA with respect to the schedule property is schedule B property, whereas the impugned order refers to schedule A property, even though the IA is with respect to B property, and hence in the appeal we have referred to schedule B property, my lord.
These objections in MFA 5939 of 5935 of 21 is over. Yep. 28.3.
My lord, I may be permitted to it may be dispensed with respect to the other respondents as the caveat counsel has already taken notice on the last hearing.
Are they not contesting respondents?
They are the contesting. They have learned caveat counsel has already taken notice, my lord, on the last hearing.
Caveat is filed for whom?
All the respondents,
Or
my lord.
7.
But caveat counsel has taken notice on
Srinivas Murthy for 7th.
on the last hearing date, my lord.
4 to 16, 4, 6, 8.
4 to 6 and 8, my lord.
4, 6, 8.
They are the same parties, my lord, in all the appeals.
5, 4 to 6. Yes. Or 3. What about 3?
Respondent number 3, I will take fresh steps.
Okay.
Please.
Sri Srinivas Murthy, advocate, has filed wakalat. Respondent 8. In MFA 5939 of 21. So therefore, issuance of notice to 4 to 6 or 5 is not necessary. Or 4 and 5 is not necessary. Time is granted for process fee, issue notice to harm.
Interim order may be kindly extended.
Already the interim order.
5939.
Next state. So all these appeals. It is.
Please, man. Lord, office objection.
4.
Please.
Appearing for the appellant's counsel. I am appearing for the appellant's counsel.
Yes.
Lord, suit.
Yes.
The suit is not for specific performance on the basis of a power of attorney executed, my lord, by the defendant, allegedly by the defendant, my lord.
Yes.
Agreement of sale is by on the basis of a alleged power of attorney. May I request your lordship kindly see, my lord, page 171. The entire thrust of our contention, my lord, flows from this document. Page 171, my lord, is the power of attorney, on the basis of which, my lord, the agreement of sale is alleged to have been executed by the power of attorney holder, my lord. This was executed, my lord, 76, my lord, in the year 1976. Our specific contention, my lord, is that this power of attorney was executed only for the purpose of purchasing the property, my lord, in favor of the attorney. If my lords were to see, my lord, first paragraph itself, my lord, about 5 lines, my lord, 6 lines, my lord, from the top. And whereas, my lords get it, my lord, and whereas the principal is not in a position to, my lords have this, my lord, 171, my lord.
Does the principal intends buying a sign?
Please, my lord.
Yes, please read.
Whereas the principal is not in a position to present, to negotiate, transact for the purpose of the site and the house at Bangalore. And for that purpose, it was found necessary and essential to appoint. But this was only for the purpose of purchasing the property, my lord. He had no power, my lord, to sell the property. The document which is executed, my lord, in the year 1976, my lord, is sought to be made use of, my lord, for the purpose of, my lord, agreement of sale. Our specific contention is, my lord, it is a fake document, and, my lord, the forgery is there, police complaint is there. All these things are there, my lord. FIR is also registered.
That on the basis of power of attorney, he obtained an agreement.
Yeah, they say, my lord, the agreement of sale is obtained. My lord, our specific contention is, my lord, there is no power entrusted, my lord, to the attorney to execute any sale deed. This power of attorney got exhausted, my lord, on execution of a sale deed, my lord, in my favor through the power of attorney. That was, my lord, in the year 1976 itself.
Where is agreement?
And this power of attorney holder is no more, my lord. He died on 21/2/2014.
Is there a reference to this power of attorney here?
Yes, my lord. My lord, first paragraph, when they describe, my lord, about the defendant, my lord, represented in the first page itself, my lord. My lords will get it, my lord. First page of the agreement of sale itself, my lord, it is represented by the power of attorney holder.
Yes.
Lord, this being the state of affair, my lord, the appellant before my lord, is about 70 years old, my lord. She is not residing in India, my lord. She is residing in America. My lord,
yes.
May I request, my lords, kindly see, my lord, page 65, my lord. Page 65, the order sheet. My lords will get an order dated 12/2/2021, my lord. Page 65, my lord, is the order sheet of the court, my lord. My lords have this, my lord. The later MS advocate appeared, submitted different, executed a power of attorney in favor of Chandra Mohan and filed a wakalat for the defendant through the general power of attorney. Hence, the office is directed not to issue summons. My lord, he is the gentleman, my lord, who has engineered all this, my lord, the agreement of sale. They were about to obtain an order of my lord, specific performance, my lord, but through all these persons, my lord. Immediately, my lord, we came to know about this, my lord, and wakalat was terminated, and thereafter, my lord, a new council was appointed.
Is A.N. Chandramohan?
Yes. He is the brother. He is the brother of my lord, the defendant. That is, my lord, the appellant before my lord's, my lord.
That means he is representing you in this suit.
Yes, he made an attempt to represent me, my lord, in this suit, and almost, my lord, had colluded with the plaintiff, my lord, to obtain a decree for specific performance. Lord, I am not residing, my lord, in India, and they do not want me to sell this property. I am age old, my lord. They do not want me to.
So, injunction is granted now.
Not to alienate. They do not want me to, my lord, deal with the property and, my lord, alienate the property. I am 70 years old, my lord. I have a right to deal with my property in a manner known to me. Now, kindly see the agreement of sale, my lord. This is dated 6/6/2012, my lord.
Yes.
Suit is filed, my lord, after 8 years. And the so-called power of attorney, my lord, who was authorized to buy the property in my favor, my lord. Accordingly, my lord, this property which is in question, my lord, is purchased by him, my lord, through me, my power of attorney. He died, my lord, in, my lord, 21/2/2014. This plaintiff,
Let him come then. Let the respondent come. You know that this council has retired. Okay. Will issue notice? I will issue notice to the caveat. See, now this caveator, respond number 1 has entered caveat through an advocate. He has not appeared. You are aware that this Sriram Nayak is not appearing because then how can I pass any order in the absence of caveator? Appellant's counsel on time of admission, it is full stop. It is submitted that by the appellant's counsel that Sriram T. Nayak, appearing for the caveator, has sent an email that he will not appear. He has issued no objection to the first respondent for engaging other counsel. This new respondent number 1 needs to be heard for granting any interim order in this appeal. Let's issue notice to R1.
all 3 minutes.
Therefore, R1 and also respondents 2 and 3. Yes.
Can I seek, my lord, an interim order till then, my lord?
How can I grant? The caveat is there. Yes, next. All right, emergency.
Please.
Excellent.
Some type of education, this is abstract case.
Come back, any matter posted.
He was also not sure, man, right?
Your application is rejected.
Yes.
The suit is,
1913.
suit is for what?
Declaration and injunction method. Learned judge, my lord, without any basis, as if considers that my sale deed itself is non-exist method. That's where, my lord, I am agreed. Page 22, internal page 12 of the improved order. My lord, I purchased the property way back in 2007 through a registered sale deed, that is 1 acre 20 guntas of land, my lord. I sold several portions and retained 24 guntas. In support of my possession and enjoyment of property, my lord, I have produced the RTC extract showing the extent as 24 guntas. Learned judge, my lord, considers a sale deed of subsequent year, that is 2010, to hold that my sale deed is doubtful. The sale deed was never challenged by any of the parties. They also claim title under my vendor only, and the subsequent title deed has been given credence to, and my sale deed has not been considered. Just I request your lordship to kindly peruse para 13, my lord.
I'm reading it. Plaintiff claims the right over the property to the extent of 24 guntas, including the property of defendants.
Then I don't, how can I claim that? Well, I claim my title through a sale deed, and I have produced the relevant sale deed along with the RTC extract. And the learned judge, that previous sentence, it shows that the defendants have purchased during the year 1996 and 2010, that is subsequent sale deed. Mine is 2007. But how can I claim a right over the property belonging to the defendant? That's where, my lord, I am aggrieved.
He submitted the lease sale deed, submitted plaintiff is concocted and created. However,
and concocted and created. How can such a finding be recorded in a by considering INA birth? My lord, is registered sale deed. The revenue documents have been produced, and they never dispute that sale deed. Their vendor and my vendor are same. Mine is of the year 2000, after a lapse of 14 years, that too, without there being a challenge to the said sale deed, on the basis of written statement, learned judge holds that mine is concocted, and that's why I filed a suit for declaration.
Your sale deeds, you purchased in the year 1993.
No, my lord, that is 2000. See, my vendor purchased in 1993. The learned judge reports that he has sold certain portion, but even then also the defendants have purchased subsequent to my sale deed.
Sold the property plaintiff to register sale deed 2007.
7, my sale deed.
The entire extent plaintiff had sold the portion of the land.
96 early 2010 several portions my vendor has sold and sale. Learned judge holds that my sale deed is concocted. Registered sale
Now
deed.
they claim under you.
No, they are not claiming under me.
Then?
That's where, my lord, I am aggrieved. I have not, my purchasers have not come before the court, my lord. 1 acre 20 guntas, I have admittedly sold 44 guntas. I have not filed any.
What is the total extent?
That is in the entire survey number, my lord. The total extent is.
No, your vendor, how much did
he had purchased 3 acres 33 guntas. He had sold me 1 acre 20 guntas.
3 acre 33 guntas in survey number?
15, my lord. That 15/1, it was subsequently coded. Mine was assigned with separate survey number 15/11.
How much did you purchase?
I purchased from him 1 acre 20 guntas. I sold 44 guntas.
Yes, my lord, I retained 26 guntas, sir, 46 guntas, I retained 24 guntas.
Whom did you sell 44 guntas?
I have produced the sale deeds also, my lord.
Yarak kodu, yarak na?
I have sold it to one Pratap Reddy. Fourth Pratap Reddy. I have produced the sale deed also. And each and every sale, madam, in persons 11 sketch was also produced. And subsequently, revenue entries were mutated, deducting the sold portion. I produced all the documents for the record.
What is the suit filed against you? First defendant.
No, I have filed a suit for declaration and injunction. They have not filed any suit against.
Earlier, the defendant number had filed suit for relief of declaration.
That is a different defendant, my lord, in respect of other extents, sir. That's why.
478 of 2011.
It was the suit schedule property was not a subject matter. I did not participate, my lord. I have categorically stated that those that area does not belong to me. They were claiming right under my vendor. That's why I kept quiet. As far as my extent is concerned, my lord, I have not sold and I have retained it. The injunction suit they were not touching my property. I kept quiet, my lord. Although I appeared before the court and subsequently, because they were not claiming any right against me, I did not participate in this suit. That does not mean that my lord, they can encroach upon my land. (2021) RTC also, my lord, shows my name in respect of 24 in the set survey number. That is, my lord, coded area, that 15 acres, 15/11.
Plain ಕೊಟ್ಟಿದ್ದೀರಾ? Where is it plain?
Page page 10. I produce IM.
Your vendor Nikhil Kotak also purchased 1 acre 20 guntas.
ಅವರು ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
1 acre 20 guntas.
I purchased 1 acre 20 guntas. They claim
your vendor
he purchased 3 acres 33 guntas.
But ನಿಮ್ಮ plaint para 3 ಓದಿ. Well, it is stated, the meaning that can be gathered is that 1 acre 20 guntas was purchased by Nikhil Kotak.
Nikhil Kotak, my lord, say.
He originally belonged to Nikhil Kotak. But the same through register said he also purchased it here 26/7/93.
90, he purchased during 93. He sold it to me during 2007.
Yes, yes.
Recorded.
Statements. Who is a contesting defendant? Contesting defendant.
I have time with the statement from objection before the trial.
2 and 3.
2, 1 and 2. 2, 3,
and
4 are the contesting. And they have not filed objection. They have filed a memo. Read the written statement. Defendant number 2, 3, and 4 have filed written statements.
That's may kindly be proceeded.
That's my submission, my lord. I have produced the documents. They say that Nikhil Kotak had no title with regard to the property, but they claim title subsequent to my sale deed from Nikhil Kotak. That's where
see, your sale deed is of the year 2007.
They claim.
Now please read para 9 of the written statement.
Written statement, but that is not the entire extent, my lord. That's where.
They say that Nikhil Kotak farmed the layout in 3 acres 33 guntas.
Yes, my lord.
And sold all the sites.
All the sites they say, but
2 and 3 are the purchasers of one
they
such
claim
site.
this purchase subsequent to my sale deed. Then Nikhil Kotak should.
Maybe, but
Nikhil Kotak should not have sold the property which is already sold to me, my lord. My respectful submission, I purchased during 2007. They purchased certain site during 2010. So on the date of purchase,
They refer to a sale deed dated of the year 1994.
there are so many sites. 2010. So at least, my lord, to the extent of sale deed covered under 2010, my lord, Nikhil Kotak had no title. But he has already sold it to me.
What should happen to the 94 sale deed?
94 sale deed, only certain sites have been sold. Remaining extent 1 acre, 20 guntas. He had 3 acres, 33 guntas, my lord. His site sold.
See, Nikhil Kotak per 3 acres, 33 guntas. 33 guntas. Their case is that he farmed the layout entire land.
No, my lord, that's where, my lord, I have purchased, that's revenue documents, 11E sketch supports my case, wherein, my lord, remaining extent, he should have formed a layout in 2 acres of land only. That to a revenue layout, my lord, it was no permission was taken. They are not produced any layout plan as such. I purchased during them 2007. And subsequently, some sites, I don't know, my lord, why Nikhil Kotak sold. My submission, my lord, in respect of site which were subsequently purchased, that is subsequent to my purchase, my lord, will suffer from, because Nikhil Kotak had no right or title to convey the portion of lands when he has sold already 1 acre 20 guntas to me. Representatives are standing in my name. And they have to substantiate their position with regard to the site, my lord, whether it is falling under my area which I have purchased from Nikhil Kotak. That sale deed also is also 2007.
It is a vacant site now.
Vacant now. 12 guntas were vacant, my lord, because during the pendency they proceeded with the construction. Unfortunately, COVID-19 has happened. We could not fight it. In spite of, subsequently also I filed one more IA to prevent them from dumping the debris and all these things. Unfortunately, it took time to get adjudication for the honorable trial court, my lord. Now another 12 guntas, recently they have started construction. At least where they have not yet put up construction, let a status quo be maintained to that extent. Already constructed the area, I will take the course of trial and see that I get my right adjudicated. As far as the vacant area wherein I have claimed a right, let it be maintained. Let them maintain an status quo with regard to the vacant area.
If you agree to a particular status, I will not. Both of you should agree to a particular status. What is the status now? Actual status?
Now, my lord, I submit, my lord, certain area out of 24 guntas, my lord. They have already developed in 12 guntas, my lord. I do submit, my lord, because I could not get the interim order. The construction went on. When I filed the suit, my lord, it was a vacant land. Subsequently, they have developed land. I will substantiate for the. And now recently, my lord, they have started digging the trenches in the vacant area. Let there be a status.
Long back after taking the license and building.
In that area, I
not make any intention of our sale deed was subsequent prior to.
See,
it's totally different.
Let it be decided by the trial court.
Yes.
So far as this appeal is concerned, certain extent of land, you have raised construction.
Already, it's going on.
He says that another 12 guntas is still vacant.
I'll just ascertain if this vacant land is there or not. I will come back to court and report because suddenly it has been.
That is so.
I will
you maintain the same status.
Remaining area, my lord, says my lord, is 12 guntas out of 20 guntas. What is claiming? Now, your lordship, can see the grade schedule as well as IA schedule. He is seeking the injunction again. Injunction in so far 1 acre 20 guntas itself.
Out of
24 guntas, not out of.
No, my lord, only 24 guntas. Out of that, I have.
That's why the trial court said it is not possible to identify the land itself.
Out of 10, that is the schedule shown in the sale deed itself, my lord.
Even IA before the honorable court also, he says 1 acre 24 guntas is in possession and enjoyment.
So sale ಮಾಡಿ we have said specifically contained at that.
Schedule A, please read.
Schedule B. Schedule B I have separately mentioned. That is the entire schedule, my lord. Which
application was the schedule property.
Schedule B. Schedule B I have mentioned.
Please read the application.
Schedule B, my lord.
Application filed in the trial court.
Trial court, trial court. Schedule B, minor. All the piece and parcel of land bearing old serve 15, new serve 15 per 11, slave 1, Kata number 10, MR number 5 or 93, situated out East Taluk, measuring 24 guntas out of 1 acre 20 guntas. I have given separate schedule. That is separate schedule.
Application was page number 52. Interfere with the plaintiff peaceful possession and enjoyment of social property. You big A ಮತ್ತೆ B ಬರ್ದಿದ್ದೀರಾ ಬಟ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ B ಅಂತ ಬರ್ದಿಲ್ಲ ನೀವು. What are ನಾನು meaning is that entire A and B ಅಂತ
ಇಲ್ಲ ನಾನು I have restricted because I have categorically stated in the plaint our
this is application filed in the trial court.
Also, Mr. I do, but I have given a separate schedule to schedule.
What is the use when your application prayer is not specific? It will be until
as far as that application, I will make a separate application.
Even here in
but the intention may not, and also when once the schedule.
Okay, let him say, let him, you please make it clear on the next stage. Since it is submitted by Sri P.R. Vishnath, 12 guntas of land is vacant. To this extent, the parties may be directed to maintain status quo. Respondents counsel. 6 times consulting is make submission. Based on next Wednesday.
Adjourned. I have no information. My lord, one submission I would like to make in serial number 31. My lord, in my connected matter, MFA 592 of 2022, my lord, there's a typographical error in my affidavit. Instead of 1974, it was wrongly typed as 2014. May request your lordship to kindly permit me to correct that typographical error.
Next permission.
Date ಕೊಟ್ಟಿದ್ದೀರಾ?
2 weeks ಅಂತ ಹೇಳಿದ್ದೀನಿ. You wanted 2 weeks.
Information ಇಲ್ಲ ಸುಮ್ಮನೆ ಕಾಯ್ತಾರೆ. Very good.
Somebody moved in the first hour. Money on the next date. I will permit you on the next date.
Please.
By the rejection of injunction application, let us filed appeal from the court. The appellant has filed suit for partition. When the appellant has also filed application for.
You are the plaintiff?
Yes, my lord. And defendants are my siblings.
Suit for partition, huh?
Yes, my lord.
What is the application?
Application for temporary injunction. His lordship, the differents are carrying out your construction, entering into joint agreement with the builder. Without denial of right, lordship, they are not denying my right, but they are depriving my claim and going on constructing the lordship, the residential commercial building. The claim is, lordship, they have given 15 lakhs to me.
It is for partition.
Yes, lordship.
What is the reason for rejection of your application?
Yes, lordship. Lordship, operating portion is lordship in page number 29. Lordship, in page number 27, paragraph 16. I read that. Plaintiff has produced recent RTCs for the food schedule properties.
Para 16.
Yes, lordship. Page number 27. Page number 27. It regarding entering into joint development agreement with one Ronald A. Castellino, a builder.
What is the relationship?
The siblings. Yes. Property self-acquired property of father. Defined difference.
Native and difference also children of what abject owner of
The defendants also claim will lordship. The father and mother has executed will in favor of.
Who has executed will?
Father and mother, both.
Father and mother of the plaintiff or defendants, huh?
Yes. Disputed by the
plaintiff. Plaintiff disputes the will.
It was not in knowledge of the plaintiff.
Let him prove the will.
Yes.
Else he will be entitled to partition.
See with construction now. Far as that is concerned, lordship may be protected.
When they claim will, it's a registered will.
But then they don't deny me lordship my right. Entire written statement. They're not denying my claim.
When they claim they will, that means your right is denied anta artha. What is this? What is? Yes, sir. Yes. Yes.
So for partition, plaintiff is appeal given.
Partition and maintenance.
No, madam. Suit for declaration as regard to the execution of joint development agreement and consequential for partition. The relief sought is in page number 39. Madam. Directing the defendants 1 to 5 to effect equal partition of the property pass necessary orders that's alleged say deed and the partition deed are null and void. Lord,
what is the relationship?
It is admitted, my lord. If the lordships would turn to the
I don't know the relationship.
yes, my lord, brothers and sisters. Brothers and sisters.
Plaintiff is the
sister of defendant. Defendant number 1 to 5 are children of late so and so. If your lordships would turn to page number 13, my lord, I request your lordships to turn to page number 13. Paragraphs. Impugned order. Page number 13 is the impugned order.
When was the earlier partition?
Partition was effected in 2006, my lord.
Reopening of the partition.
I was not a party. I was not a party to that partition.
Different. When did it take place?
2006.
So it is in 21.
Yes, sir.
Limitation.
Limitation. When I was not a party to it, the question of limitation does not arise.
They say that that was.
Yes, my lord. I would demonstrate that. Your lordships may just give me 1 minute.
I
request your lordships to turn to page number 13 where the relation is admitted. There are 2 things which your lordships asked me. Page number 13, my lord. Impugned order, internal page. ಕಾರಣಗಳು ಓದಿದೆ. ಕಾರಣಗಳಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ 7 ಅಲ್ಲಿ ವಂಶವೃಕ್ಷಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಯಾವುದೇ ವಿವಾದ ಇರುವುದಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ 8 ಅಲ್ಲಿ 13 Swami, in page 13, 1-3. Impugned order starts, my lord, with page number 10, annexure A. Page number 13, in page 13 is first para. 7 I have not read the entire Prativadi 7 ಮತ್ತು 8 ದಾವಾ in the first that ಅಂಶ 1 3 ಕ್ರಯದಾರರು ಇರುತ್ತಾರೆ. ಸದರಿ ವಂಶ ವೃಕ್ಷಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಯಾವುದೇ ವಿವಾದ ಇರುವುದಿಲ್ಲ. Therefore, the relationship is admitted. Next paragraph, my lord. Enterly, the father of the plaintiff has purchased the property in 1967 and 2 dates. ನೋಂದಣಿ ಕ್ರಯ ಪತ್ರದ ಮುಖಾಂತರ ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ ಎಂಬ ಬಗ್ಗೆ ವಿವಾದ ಇರುವುದಿಲ್ಲ. Therefore, there are 2 things as far as the property is concerned. My lord, now I request your lordship to turn to paragraph 10, my lord.
9 ಓದಿ.
ಓದ್ತೀನಿ. ಆದರೆ ದಾವಾಸ್ತಿಯ ವಾದಿಗೆ ಪರವಾಗಿ ಮೇಲ್ನೋಟಕ್ಕೆ ಇರುತ್ತದೆಯೋ ಅಥವಾ ಇಲ್ಲವೋ ಎಂಬ ಬಗ್ಗೆ ನ್ಯಾಯಾಲಯವು ಪರಿಗಣನೆ. ವಾದಿಯು ಚಂದ್ರಶೇಖರ್ ರೆಡ್ಡಿ ಅವರು 88ರಲ್ಲಿ ಮದುವೆಯಾಗಿರುತ್ತಾರೆ. ಮದುವೆಯಾದ ನಂತರ ಚಂದ್ರಶೇಖರ್ ರೆಡ್ಡಿ ಅವರು ಸದರಿ ಸ್ವತ್ತನ್ನು ವಿಜಯ ಬ್ಯಾಂಕಿಗೆ ಅಡಮಾನ ಮಾಡಿಕೊಂಡು ವ್ಯಾಪಾರಕ್ಕೋಸ್ಕರ ಅಂತ. This is the husband of plaintiff, my lord. He deals with some property and they claim that the defendant number 5 appears to have provided some help. That doesn't take away the rights of the plaintiff as far as the property of her father is concerned. This is what the entire paragraph reads, my lord. Now I request your lordships paragraph 10 ಒಂದು ಓದ್ಬಿಟ್ರೆ everything is clear, my lord. In paragraph 14, no, I request your lordship. I am trying to substantiate my case. Paragraph 10 in page number 14, my lord.
ನಾನು ಸ್ವಲ್ಪ ಪೂರ್ತಿ ಆರ್ಡರ್ ಓದಕ್ಕೆ ಅದು ಓದ ನಂಗೆ ಅರ್ಥ ಆಗತ್ತೆ ನಿಮ್ಮ ಕೇಸ್.
ಸರಿ. I would read it, your lordship.
I am seeing the file for the first time today.
Right?
You might have read 10 times.
Yes, ma'am. If that was the case, my lord, has
received 10 lakhs.
Yes, my lord. There is absolutely no record is produced before the court except for a bald statement made. 10 lakh rupees. No, my lord. Defendant number 5 pays 10 lakh rupees. What should be a document, my lord? They claim that it was in a OS. If it was to be in a OS, they should have paid it before the court. If it was a partition deed, it should have been paid before the sub-registrar and entered it. Mere making a bald statement. Yes, my lord. Now, what I am seeking is, my lord, now they are putting up construction. What the learned trial court ought to have made is subject to the rights of the parties to be decided. Now, here is a case where the applications are outright rejected. No, my lord. Now, in the event I am successful.
2006 partition, you are claiming the reopening of it in the year 2021.
My lord, I am not a party to it, my lord.
Then how did you receive 10 lakhs?
My lord, that is the question that is before the court, my lord. I have stated in my plaint also. I have not stated. My lord, I request your lordships to turn to my paragraph, page number 28, paragraph 16, my lord, of the plaint. It is not that I have concealed it. I request your lordship to turn to page number 28 for a moment. Plaint internal page 12, 16. Your lordship got paragraph 16.
Yes.
The plaintiff submits that the defendant number 1, Srinivasa, the husband of defendant number 2 and father of defendant 3 and 4, V. Lokesh, so and so, and defendant 5, Prabhu Kumar, alias alleged to have got a partition deed on 24/4/2006, registered in the office of sub-registrar and registered by document number so and so. In the alleged partition deed, the defendant number 1 to 5 alleged to have stated that the plaintiff was given 10 lakh rupees. I was not a party to it, my lord. Except for a mere statement in the partition deed executed between different parties, there is a claim of 10 lakh rupees. No, my lord, 10 lakh rupees cannot be paid, and they claim that it is paid in cash at one point of time. I request your lordships, permit me to turn to page number 87, my lord. 87 is the written statement of defendant number 5. Ink page 87, my lord. Your lordship got it. Paragraph 11, my lord. The averment made in para 11 of the plaint are specifically disputed, denied, and put to strict proof of the same. It is submitted that defendant number 5 had himself called the plaintiff for partition and signed the deed of partition, as she has already demanded and received 10 lakh rupees by way of check when the defendant 5 sold 28 so and so to 1 Ravi Chandra, exchange dated 2/12/2005. The plaintiff did not sign the partition deed even after having received the said 10 lakh rupees, but strangely she had filed a suit for partition in so and so on the suit scheduled property on 6/12/2005 within 4 days of having received the said amount. It is further stated that the plaintiff again demanded and received 10 lakh rupees by cash. This is not the case of the plaintiff at all. I am not claiming that I have 20 lakh rupees is paid.
What is the suit? OS 9682?
A suit for entire properties of the family, my lord, ancestral properties and all those things.
Filed by you.
Filed by all the sisters, brothers, including the defendant number 5.
What happened to that?
The suit came to be dismissed for default. 10 lakh rupees cash ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತಾರೆ, 10 lakh rupees check ಕೊಟ್ಟಿದ್ದಾರೆ. At least the defendant number 5 ought to have produced document to the court to show that yes, 10 lakh rupees is paid, except producing the claim that the suit is dismissed and making a averment that 10 lakh rupees is paid. The trial court on the averments of the defendant 5 accepts the contention and dismisses the application. At least the court ought to have given, all right, in the event the plaintiff succeeds, he should not claim equity or some such thing.
Right, notice.
Last week of the matter was come before the court. The landlord and tenant relationship between the parties. The relationship admitted and lordship we discussed that. Thereafter, the terms are we asked finally 15 months time. They come forward to till the end of this year. Now terms is they are not ready to pay the. They are agreed, but they are ready to pay the time till 9 months. But they are demanding 25,000 rent, and they are not ready to pay the whatever the consideration received by them spent for the overall BWSSP connection, water connection, DESCOM charges, whatever we paid for obtaining the service, power connection is concerned. That deposit they are not ready to pay. For that matter is not settled in the parties.
I appeal for the respondent in this matter. Lord, in order to resolve the dispute amicably, my lord, yesterday we had a discussion, my lord. In fact, the learned counsel for the appellant gave a proposal that he would require 1 year time, further extension. My lord, may kindly see the lease period expired last January 2021. Already more than 1 year has elapsed. Despite that, my lord, my client gave a proposal that he would enhance further period by 6 months, subject to him paying the enhanced rent. And yesterday he was insisting that he would vacate in the month of April. Today morning I secured instructions. Upon my persuasion, my lord, my client has agreed that he would enhance further 3 months time and let the appellant vacate the premises by the end of December and hand over the scheduled premises in the new year to the respondent, to which he is not agreeable. My client has agreed to enhance period by 9 months, subject to him enhancing the rent and resolving the dispute.
React
license will be expired for running service station from the DBMP Millard from started from account year from March to March. This Millard, this March to March only we have. In the middle Millard is vacated. Again we have one more trade license apply and get it. One is. Second thing Millard is they are not ready to pay the installation charges from Westcom. If they are paid Millard, they are admitted. There is a we paid through account and we have paid the amount to the Westcom.
In fact, in the return statement, we have taken a specific stand saying that the said amount has been deducted in the rates payable to the respondent. We have taken that stand in the return statement also. Kindly see page 34 of the return statement. We have said so.
Arrears is
Kindly see line number 2 of page number 34. In fact, the said amount has been deducted by the plaintiff in the rents payable by him to the defendant. We have taken a specific stand. It is not that we are saying it for the first time. 34.
Find any HRC case or suit for rejection?
Not so far. Not far. That is why, my lord, in order to avoid litigation, we have given a proposal for up to 9 months, my lord. Despite that, they are insisting that they want for 15 months, 1 year. Yesterday they came down to 1 year. Again, they are submitting that they want for 15 months. Yesterday evening they said till April. Today they are saying 15 months. In fact, previous month's rent has also not been paid. After the order came to be passed by the trial court, previous month's rent has not been paid. In fact, the respondent is also in need of the premises, my lord. His son is unemployed. Already more than 1 year has elapsed. Still again he is giving 9 months more. The appellant cannot insist for more, my lord. It would be too unreasonable on the part of the appellant.
You don't evict him without due process.
Lord, may kindly see on merits, my lord. If he is not ready for settlement, I'll submit on the merits, my lord. Because he
his application is now dismissed.
Yes, ma'am.
NC has expired. You have to take possession only according to law.
Lord, in order to avoid all this,
you will file a suit to evict him.
Lord, in order to avoid this litigation, my lord, we have given a proposal.
He is not ready. Then
He is asking till April, my lord. Therefore, I have requested him till December. You can stay in the premises and resolve the matter, my lord. In fact, yesterday they said till April.
Go to mediation.
Lord, let him pay enhanced rent of 25,000. Right now they are paying 80,500.
agreement in class.
Can't,
I oblige me, Lord. My submission for the court. 3 months prior notice has to given to me before taking any.
That is during the lease period, my lord.
In
That
the
is
lease
during the lease period.
Lease period.
Lease period
If
is
they want to
expired.
terminate, if they given a notice, Millard, previous 106 notice, Millard under TP Act. Certainly, Millard, we will make alternative arrangements and other things.
My learned
They
friend
did
is
not
mixing
take
up.
any action.
My learned
They are not
friend is-
ready to pay the deposit amount to the Westcom authorities. He has not provided. He kept quiet for digging borewell. And we for running the water service station, Millard, is the water is only the important. Millard, at the cost of the petitioner appellant only this borewell has been dug in the premises with the consent and permission of the owner. Now, Millard, we are ready to give left all the things. We will earn from the very same from the premises until April, Millard, at least 15 months we asked Millard to them to provide, and we are ready to file necessary affidavit before the court to vacate and hand over the keys. He is not ready to pay all the amounts.
Yeah, therefore, you go to mediation.
That's why we are ready.
My lord, I am agreeable for April. Let him pay the enhanced rents and close the matter.
ಮಾಡ್ಕೊಳ್ಳಿ.
Like ಏನಾಗುತ್ತೆ ಈಗ
I will not interfere.
like he is not given the previous month's rent also.
ಸೂಟ್ ಹಾಕೊಳ್ರಿ ಹೋಗಿ.
ಅಲ್ಲ,
Eviction suit ಹಾಕೊಳ್ಳಿ.
My submission is presently paying 18,500 and lease period expired January 2021. Even if 10% enhancement is considered, it would be about 3,500. So 18,500. Let him pay at least 22,000 and close the matter, my lord. I'll expect my client not to press for 25,000.
No such
He is also not sought for the recovery of the alleged borewell expenses, Westcom expenses. He is also not made such claims before the trial court. For the first time in the appeal, he is raising such matters. Therefore, it should be reasonable, and yesterday is given an offer till April. And when I agree for April, now he is saying all those claims are there and other. April 1st, let him vacate, my lord. Let him give the enhanced rent of 22,000 and close the matter, my lord. Let him file an appeal.
45,000 only he has to pay the BESCOM charges.
The BESCOM charges are not sought to be recovered before the trial court also, and I have specifically denied in my written statement.
So you are the plaintiff.
Absolutely.
You have filed this appeal and suit to compel him to come to some understanding for your
Absolutely.
I can observe that your hands are not clean.
We paid.
You can't put him on, you can't take advantage just because you are in possession.
We are not putting blood till February. We paid rents.
He is so reasonable.
25,000 millard, all of a sudden not detecting any.
22,000 I am saying. 22,000. I reduced 3,000 already.
22,000 we are ready.
But
subject only 45,000 he has to repay.
Again he is raising all those things.
Only one thing.
Unconditionally, if you are ready for, otherwise I would.
22,000 we are ready.
This suit is only to see that
not to dispute.
We should yield to your demand.
Absolutely.
Absolutely.
Yes, Millard, I agree, because that is our case.
Then I can dismiss your appeal.
22,000 we are ready to pay. April.
That is what I am saying. 22,000. April 1st I am saying.
22,000. That is what you want.
But 45,000. 45,000 what we paid the deposit to the BESCOM, they are not ready to pay that amount.
That is
That
not
is
sought to be
black
recovered
and
before
white.
the
There is
trial
a
court.
white and white.
In fact, he is deducted from the rents payable.
Only that
Now he
issue
is not
only there.
justified in making such.
Refer the matter to mediation, we will come to, otherwise next week, Millard, we will come to a joint. For the court here.
Kindly, Millard, he is given proposal till April.
No, ready.
I have said 25,000, I reduced to 22. Now again, they want to buy time by getting the matter referred to mediation, Millard. I am coming to his terms.
The court, Millard, we are ready.
I will dismiss your appeal.
I am coming to his terms.
I will dismiss your appeal.
We are ready, Millard.
Don't put any more conditions.
No condition, at least deposit through $30,000 kodal, we have to again file recovery of amount again.
That is not sought in the case. Now they are raising. In the main suit, it is not sought.
I will post on Friday. Within that time, you must come out with some solution. It's on Friday. Unconditionally, you must agree.
And the previous month's rent also is not paid.
I feel that.
Yes, next.
18.
Defendant 5 has filed this appeal, Millard, questioning the temporary injunction granted by the trial court. Thereby, the trial court passed the temporary injunction restraining the defendant 5, that is the appellant herein, for putting up any construction on the B scheduled property. Last kindly see, it is actually ex parte order passed by the trial court. Your Lordship kindly see Annexure A.
Annexure A.
A, that is the amended plain. Plaintiff number 1 and 2 have filed the suit for partition, separate possession, and cancellation of sale deed of the appellant herein. During
pending executed by 4 defendant
in favor of the defendant number 5, who is appellant herein. During pendency of the suit, 3-4 died. Defendant 3-4 died. Your Lordship kindly see, suit was filed during 2010 and 2019. Application IA number 11 filed by the defendant, filed by the plaintiffs for seeking temporary injunction. Page number 56. Your Lordship kindly see. 56. That IA filed by the plaintiffs. For the reason stated in the accompanying affidavit, the plaintiffs in the above case humbly pray that this honorable court may be pleased to direct to defend number 5 not to put up any construction over the Schedule B property till disposal of the suit. Then, my lord, I have filed detailed objection. After filing the detailed objection, it was posted on 10/1/22 for argument by both sides. Then the plaintiff, without knowledge of this defendant, advanced the case. Your Lordship, kindly see the 64, page 64. Page 64. Plaintiffs have filed advancement application, advancing the case from 10/1/22 to 16/12/21, page 64. That is annexure D, my lord.
Copy received, advocate for
Copy issued by defendant 1 to 3, not by defendant 5. Defendant 1 to 3. Not by defendant, it is not served to the defendant 5. Then, my lord, your lordship, kindly see, I will show the order sheet. How the plaintiff and defendant 1 to 3 played a fraud on the court and misrepresentation to the trial court. Next, your lordship, kindly see. I have produced order sheet, annexure G, page number 70. My lord, annexure G 82. That is a annexure 68. It starts your lordship, annexure G, page. It starts 75. Relevant paragraph, page, your lordship, kindly see, 90. 90, it is a typed copy. That order copy is, your lordship, kindly see, page, what is 16 to 82, page 82, relevant page. That is the trial court order sheet, certified copy. The advocate for plaintiff left side filed application under section 151 of CPC for advancement of the price that advanced the case. Case has been taken on board. Then, your lordship, it is a better to see the typed copy.
Page 90.
Page 90, your lordship, kindly see. Before that, your lordship, 17, 11, 20, before that, 89, page number 89. Plaintiff counsel present, that is 17, 11, 21. Plaintiff counsel present, defend number 5, counsel absent for objection 14, 12, 21. On 14, 12, left side for objection. PO is on CL or permission adjourned to 14, 12, 21. Counsel for D5 filed objections. We have filed objections on that day. Your lordship, kindly see, hearing. Next, it is posted on 10/1/22. 10/1/22, this was advanced by the plaintiff counsel, filed application on 16/12/21, left side, page 90. 16/12/21, advancing the case from 10/1/22 to 16/12/21. Well, on the very same day, right side, my lord, counsel for the plaintiff filed IA under section 151 of CPC for advancing the matter. Matter is taken on board. Counsel for plaintiff, counsel for D5 present. It is wrong note because for the reason copy has not been served. I was not aware, my lord.
You can't dispute the what is written in the order sheet.
My lord, I was not aware the copy served by the plaintiffs. How can it is noted as a D5 is present? My lord, it is wrong submission made by the defendant 1 to 3, represented as D1 to D3, present counsel for plaintiff filed written submission on IA number 11, counsel for D1 to D3 filed memo, heard on plaintiff and defendant side. For lordship, defendant 5 side for orders on IA number 11, then for 24/12/21. On 10/1/22, your lordship, kindly see, PY is on leave. Then adjourned to 1/2/22. On 1/2/22, this order has been passed. Your lordship, kindly see, memo filed by the defendant 1 to 3 and also page number. Your lordship, kindly see, page number 68, annexure D12. The plaintiff in the above case humbly prays that the Honorable Court, the following documents same may be taken up on record in the interest of justice. Then, my lord, next memo filed by the defendant 1 to 3. 3, the defendant 1 to 3, D died. Defendant 3 died, my lord. In spite of that, D3 advocate, he filed this memo. The defendants 1 to 3 in the above case humbly prays that the Honorable Court, the application filed by the plaintiff may be allowed. The defendants 4 to 5 have no right and interest over the suit schedule property without knowledge of the plaintiff, and defendants 1 to 3 created for the documents and registered in the same in the name of defendant number 5 is illegal. The defendants 1 to 3 agreed to give share in the suit schedule properties. Hence, this Honorable Court may please to allow the application filed by the plaintiffs in the interest of justice and equity. But it is a collusive suit between defendant, plaintiff and defendant 1 to 3.
But you are present on
Lord, it is,
16/12/21.
Lord, I was not served the copy. Copy serve ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ ಇದು ಕ್ಲಿಯರ್ ಆಗಿದೆ ಡಿಪೆಂಡ್ 1 to 3 ಸರ್ವ್ಡ್ ಅಂತ ಅವರೇ ನೋಟ್ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ. I have produced order sheet.
Heard on plaintiff and D5 sides for order.
Plaintiff defendants ಅಂತ ಹೇಳ್ತಾರೆ. ಅವರು ಡಿಫೆಂಡೆಂಟ್ 5 ಅಂತ ರಾಂಗ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ಇನ್ನು ಟೇಕನ್ ನೋಟ್ ಆಫ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ನೋಡಿ ಇಟ್ ಇಸ್
ದಯವಿಟ್ಟು ಓದಿ ಇಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಹರ್ಡ್ ನೋಡಿ heard on plaintiffs and D5 sides for orders on IA. ಅರ್ಥ ಇಲ್ಲ
ನೋಡಿ ಇನ್ಚಾರ್ಜ್ ಕೋರ್ಟ್ನೇ ಕರೀತಾರೆ, ಅಲ್ಲಿ ಯಾರು ಕರೀತಾರೆ ಯಾರು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರೆ ಅಂತ ಗೊತ್ತಾಗಲ್ಲ ಸ್ವಾಮಿ. ಇವ್ರು
ನೀವು ಇದ್ರಿ ತಾನೆ
ಸ್ವಾಮಿ, ನಾವ್ ಇದ್ರು ಸಹಿತ ಮಧ್ಯಾಹ್ನದಾಗ ಕರೀತಾರ ಅಂದ್ಬಿಟ್ಟು ಡೇಟ್ ಕೊಟ್ಟಿರ್ತಾರ. ಅದು ಹಂಗಾಗಿ ಅಡ್ವಾನ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ ಗೊತ್ತಿಲ್ಲ.
ನೋಟಿಸ್ ಅಷ್ಟೇ
ಅಲ್ಲ ಸ್ವಾಮಿ, 24ಕ್ಕೆ ಐ ಹ್ಯಾವ್ ಟು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್
ಮಾಡಿ.
ಅವ್ರು ಅಲ್ಲ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಡೆಮಾಲಿಷನ್ ಮಾಡಕ್ ಅವ್ರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ.
ಸೂಟ್ ಮುಂದುವರಿಲಿ ಬಿಡಿ.
ಅಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ಡೆಮಾಲಿಷನ್ ಗೆ.
ನೀವು ಬಂದಿರೋದು ಅಪೀಲ್ ಇದ್ರೆ ಅಪ್ಲಿಕೇಶನ್
ಅಪ್ಲಿಕೇಶನ್ ಹಸ್ ಬಿನ್ ಫೈಲ್ಡ್ ಫಾರ್ ಡೆಮಾಲಿಷನ್.
ಸೂಟ್ ಆಗ್ಲಿ, ಸೂಟ್ ಮುಂದುವರಿ.
ಅಲ್ಲ ಡೆಮಾಲಿಷನ್ ಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. I have already put up the construction.
All right, no, yes.
Notice, your lordship kindly permitted to serve the copy to the trial court advocate. I may be permitted to serve.
Notice to the respondents. Appellant's counsel is also permitted to take
It is
case to the counsel for the
suit is posted before the trial court for cross examination of plaintiff.
Yes. Yes, next. Continue to tell.
Kindly on 21st, your lordship, 22nd it may be called. I will serve the copy. I will serve the copy to other side.
Yes.